I'm gonna do my stuff here. All right. Well, good morning, everybody. Today we had the pleasure of Mr. Andrew Foster from Harvell and Collins joining us to talk about estate planning and the thing we don't want to have to think about, but one day we're all going to be interned someplace and might as well be legally responsible for what is going to happen to our heirs and our estate and our homes and financial resources, etc. So Andrew's a UNC graduate. We already had that discussion. So, I went to NC State, so and we have not won a game since like forever until this year. But nonetheless, we're happy to have you here today, Andrew, and just let him do the presentation, get into it for a little bit. I'm sure there will be some questions, and please recognize that individual discussions on a very specific point probably need to go into a one-on-one situation at his office. So he'll give you a general overview of things that you all need to be prepared to know about, so that you can make those decisions about how you want to handle your estate. So Andrew, without further ado, I'll turn it over to you.
Well, thanks everybody for being here. Like you said, my name's Andrew Foster. I'm an attorney with Harvell and Collins. I've worked for Harvell and Collins for the past 11 years. Can't believe it's been that long. I'm originally from Fayetteville, North Carolina. Went to school, as he said, UNC Chapel Hill. So I'm always go Tar Heels. I went to law school at North Carolina Central University, and also got my LLM in taxation, which is a master's in tax law, from the University of Florida. So I heard to go Gators back there. So I'll say that too. What I want to talk to you guys today about are our basic estate planning documents, and then get into a little bit more of advanced planning and just kind of touch on that so you guys can understand what services are available through Harvell and Collins, and what we can do to help try to protect your assets, ultimately for the benefit of your beneficiaries, and keep it away from the state of North Carolina and the federal government as much as possible. So that's what we're working on. So we'll start with just our basic estate planning documents, and those are last will and testament, durable power of attorney, healthcare power of attorney, HIPAA release, and our living will. So we'll start with those, and I'll go through each one of those documents and what purpose they serve, and then we'll get into some trust planning, and as part of that trust planning, we'll talk about asset protection planning as well. Okay? So let's start with our last will and testament. I think you guys have heard that term before. You hear the reading of the will in these movies and various things like that. So what is a will? A will is a document in which you decide where you want your assets to go when you pass away. Okay? So that's a very, very important document, as you can imagine. You also get to choose a person called an executor, an executrix, to be able to handle your affairs after you're done, to make sure that your beneficiaries are treated equally, that your expenses are paid, finalized, and that your estate is handled appropriately. Obviously, that's a very important position, and we'll get into these fiduciary roles and talk about how important they are. So last will and testament, what you want to do is you want to make sure that you provide for whomever you want to. And that's the thing about a will. You can make it your own, okay? And if you make it your own, you can decide who you want your assets to go to, whether it be your spouse, whether it be your children, whether it be friends, family, relatives, whoever it may be, charities. You have the option to basically say, this is where I want my assets to go, and kind of the sky's the limit relative to who those beneficiaries might be. Let's talk about if you don't have a last will and testament, what happens? Well, the state of North Carolina steps in and says, these are our default beneficiaries. And basically, as you can imagine, it's spouse, children, if not those, parents. If not parents, we're going out to brothers and sisters. If not brothers and sisters, we're going out to nieces and nephews. Then eventually, if we just absolutely have no one, then your estate would go to the state of North Carolina. We call that a sheeting to the state of North Carolina. The problem is that most people sitting in this room right here, if I were to tell you the true intestacy laws, you'd say, that's not what I want. That's not what I want to happen with my estate. We run into this problem. I'll just give you a classic example. We run into this problem with real property all the time, okay? If you own real property in your name and you have a spouse, and it's just in one of the spouse's names, and you have children, then a lot of people are under the misconception that that real property will automatically go over to my spouse when I die. That's just simply not the case in North Carolina law. If you own property in your individual name, it doesn't matter whether you have a spouse or not. If you have a spouse and you have kids, the way that it works is part of that property is going to your spouse and part of that property is going to your kids. And we see this a lot, unfortunately, where we have minor children inheriting property because let's say we had a child and that child passed and we have grandkids. Keeps going down the line, and we end up in situations at Harvell and Collins a lot of times where someone did not plan their estate properly. They end up in an intestate situation, and now we're ending up with assets going to individuals who either shouldn't get them, number one, or number two, have no ability to receive them because of the laws of North Carolina regarding minority status, being 18. So it's very important to understand that those default rules really do not accomplish your goals at the end of the day. That's why everyone sitting in this room right now should have a last will and testament to be able to say how you want your estate to go at the end of the day. Very, very important document. And the good news is you can leave the estate, you can do specific bequests of property, tangible items, things like that, sums of money to various people, and ultimately percentages. You know, at the end of the day, if I have a pie, and my pie gets bigger or smaller, it doesn't matter. I want these percentages to go to these particular people because I want them to share equally in my pie at the end of the day. I mentioned executors, executrixes. Very important role because the person you appoint to this position is a fiduciary. What's a fiduciary? A fiduciary is someone who acts on behalf of another. It's an easy way to describe it. And that fiduciary is going to be in charge of making sure that your estate is handled appropriately. And you want that fiduciary, that executor, to be responsible for making sure that your last final affairs are taken care of and that ultimately your beneficiaries, again, are treated fairly and equally. Okay? In conjunction with the will, I want to talk a little bit about account designations. So a lot of you sitting out there right now have bank accounts, investment accounts, IRAs, 401ks, various things like that. And what we want this last will and testament to do with those beneficiary designations is mesh like this. Okay? Because the problem is you can come to my office and we can do the best estate plan in the entire world. But if you go sit in your bank and you make certain changes to your accounts, or you go sit with your financial advisor and you make certain beneficiary designations, and they're not simpatico with your will at the end of the day, well, that's not an estate plan. You know, you have a will, you have designations, you're not planning. Planning means you're putting them all together to make sure that your goals are accomplished at the end of the day. So it's very important during an appointment that we go asset by asset with you guys and we say, okay, how's this account held? Oh, it's held jointly with my spouse. Great, fantastic, wonderful. That's exactly the way it should be. Or, you know, oh, I've lost my spouse, so now it's just in my name. Okay, what are the ramifications of that? We talk about the tax benefits of naming beneficiaries to IRAs and 401ks so they can pass directly out to beneficiaries. There's also some IRA trusts that we can talk about later on that can help if you're concerned about someone inheriting money through those IRAs, but we want to keep those tax favored treatment. So I'm saying beneficiary designations and account designations are very important because we want those to mesh with your will. We don't want them to run contrary. One of the classic examples we see at Harvell and Collins where the plan unfortunately gets messed up is we have spouses, we lose a spouse. We have multiple children down here who are all treated equally under a will. And when that spouse passes away, we have one child then that gets added to an account as a joint owner of that account. Okay? What does that mean? That means we have joint owners, we have parent, child. That account now is subject to the twists and turns of that child's life. Accident, judgments, divorce, tax issues. Oh, I hate when the tax man comes a calling for mommy and daddy's account that child's on now. Also, at the end of the day, that account legally passes over to that child. So if you have 3 or 4 children down here and you've got one child that's on that account, that child inherits that money. And I'm telling you guys, it's a coin flip about whether that child decides to share that money with their siblings or that child decides to say, I think daddy or mommy wanted me to have this account. And trust me, that doesn't go very well. So these account designations are so critical and so important, and it's just, why I go through every appointment, we go through every account, we go through every designation, and we make sure that those designations match up with what you want under your last will and testament at the end of the day. Durable power of attorney. So this is the person who would handle your affairs during your lifetime, okay? So if you get into an accident, if you have a medical emergency, and you have someone who's going to pay your bills, who's going to manage your assets, who's going to take care of that to make sure that your affairs are taken care of when you're unable to do this, okay? If you have a durable power of attorney, you name that individual. Could be your spouse, could be your children, could be a friend, could be a family member. Any person that you deem to be that fiduciary role and be able to take on that responsibility and handle your affairs appropriately, that would be your power of attorney. Under North Carolina law, we call them your agent. Okay? What if you don't have a durable power of attorney? Well, if you don't have a durable power of attorney, then the only option you have if you end up in the situation with a medical emergency, or you end up in a situation where you've been in some type of accident and you have no one designated to pay your bills, is what's called a guardianship. You may have heard this. In certain states, it's called a conservatorship. What it means basically is that the court picks a person, and the court designates that individual to be appointed as the guardian of your person, which means they make decisions relative to your health, or a guardian of your estate, which means they make decisions relative to your estate. And that individual is going to be accountable to the court. And trust me, it's a process. You have to get appointed. It's difficult. It's an arduous task to go through a guardianship, and it puts a lot of stress and strain on a family. So we hate to see these situations where individuals have not gotten a durable power of attorney to appoint this person, and our only option we have left with under North Carolina law is this guardianship proceeding. Okay? So again, it's important to have that document. Everyone needs that document and appoint those people to be able to handle their financial affairs. Healthcare power of attorney, same thing. Who's going to make your healthcare decisions if you're unable to make them? Who's going to consent to that surgery? Who's going to talk to the doctors and make medical decisions based on your behalf if you find yourself infirmed or you find yourself in an accident? That individual does not have to be the same person as your durable power of attorney. It could be someone different. Certain people are tasked more with the financial aspects, and other people are tasked more with the healthcare aspects. So that healthcare power of attorney is, again, a very important person to be able to make these decisions in the event that you're unable to do so. HIPAA release. Oh, again, if you don't have a healthcare power of attorney, you got to make decisions. What are you left with? Looking at a potential guardianship there for guardian of the person in these type of situations. HIPAA release. This is a document to allow access to medical information. So we call it the HIPAA stop sign. A lot of times doctors say, can't talk to you. Not allowed to talk to you. I don't want to breach my ethical duty to my patient. This document is going to allow that individual to be able to cut through that red tape, be able to get access to your medical information, and be able to make decisions ultimately relative to that. Now, why do we have two different documents? The standards are slightly different. So healthcare power of attorney comes into effect if you're unable to make those decisions because of some infirmity or some accident. The HIPAA release is in effect immediately. So, this allows the individual to be able to go get x-rays, get documents, talk to doctors, and be able to do that without, even if you're have capacity to make these type of decisions at the end of the day.
Can we interject with that
Go
HIPAA release?
Yes,
Who
sir.
actually should have it? My physician?
Correct. So these healthcare documents, once we have the healthcare power of attorney and the HIPAA release, copies of those documents are wonderful, and those can be put on record with the hospital or with your family doctor at the end of the day. You're exactly right. Same thing, last document, living will. So living will, the state of North Carolina is allowing you to make a decision, all right? And the decision ultimately becomes, what happens if I'm hooked up to a machine at the end of the day? Do I want my life prolonged by those machines? And the state gives you 3 different medical conditions with which you can make this decision. Terminal and incurable, meaning that you're going to ultimately pass away from this disease that you have or infirmity. Persistent vegetative state, meaning that you have no brain activity at the end of the day. And then one they've added recently is if you suffer from advanced dementia where you have no quality of life. And that basically means that you're under Alzheimer's or dementia, and unfortunately your quality of life has gone such downhill that you're hooked up to this machine. It's the only thing keeping you alive. The doctor, you can either say, I want to be these machines withdrawn from care, or I want these machines to prolong my life, and that's your decision. You get to make it. So some people think that, being hooked up to machines in a nursing home is kind of a fate worse than death. If that's the case, then this is a very important document because it says, I do not want these machines to prolong my life. It is not the same thing as a DNR. A couple people have heard do not resuscitate orders. That is a decision that you make with your doctor, and the doctor will ultimately implement that. So you may have seen people or had relatives where there's a stop sign at the front of their door. That stop sign says, do not do any compressions, no life-saving treatments to this individual. You've been through the ringer from a medical perspective, and unfortunately, it's just the point where you do not want any life-sustaining means under a DNR. That is not the same thing as a living will, which is basically we're going to do everything we can to bring you back. And in the event that you find yourself hooked up to this machine, the question becomes whether or not you want that machine to prolong your life.
Well,
Yes.
the third one was with Alzheimer's?
Yes.
Okay, can you review that with me? Because obviously, if a patient has Alzheimer's,
Yes.
they would be considered incapable of making a decision. So
Correct.
this would have to be made prior to.
Exactly.
doing Alzheimer's.
Yeah, all these documents that I'm mentioning to you right now is a very good point. So that's why it's so important to get these documents done now while you're healthy, you have capacity, because these documents will move through that. That's when we'll talk about durability of a power of attorney, for example. It means it stays beyond your incapacity at the end of the day. So if you find yourself in Alzheimer's, dementia, if you find yourself in medical, we talked about infirmity or accident, these documents are what will guide your fiduciary through this, guide the doctor through this relative to what your wishes are. So that's why you have to have them while you're competent, while you have capacity to make these decisions, and then they will sustain you through these twists and turns of life at the end of the day.
You mentioned DNR.
Yes.
When, and given that that is a separate decision,
Yes.
when is that determination made? Is it at the time of a catastrophic event?
Yeah, so normally that's exactly right. So, the hypothetical I'll give here is that someone has been diagnosed with some type of terminal cancer or even just cancer in general, and they have gone through chemo, they've gone through radiation, they've gone through all this stuff, and finally get to the point where we've done everything we can, and if my heart stops, I don't want you to try to resuscitate me and bring me back because I've made my peace with this. But those are the type of situations where I'd say DNR. Now, unfortunately, what happens a lot of times is that your designated healthcare agent has to make that decision at the end of the day, because if you do find yourself in an accident such as you described, then someone needs to make the decision to say whether or not this person would want a DNR at the end of the day. I had an unfortunate circumstance in my life where my brother suffered a very catastrophic stroke. They put him on a ventilator, rushed him up to UNC, and they asked me, they said, if you thought about whether or not you would be interested in having a DNR for your brother at the end of the day. Now, ultimately, I didn't have to make that decision because his condition improved, but that was broached with me by his doctor, and I, being his healthcare agent, was the one who had to ultimately think about that decision. But obviously, if you have capacity to make it, you're the one who enters the DNR yourself. So there's kind of two different ways that could work.
So that says to me that
Yes.
communication between that person you have designated as a healthcare power of attorney and, the issues related to living will.
So important.
That discussion has to take place.
I agree, yeah, definitely. And one of the options you have on your living will is you can check a box saying follow this declaration, which means that you want that document to speak for itself, meaning I do not want machines. Or you can check the box saying follow my healthcare agent. And if you check the box saying follow my healthcare agent, you're saying I'm putting all my power in my healthcare agent. Y'all might remember the Terry Schiavo case from back in Florida. And, you've got a healthcare agent saying one thing, which is keep her alive, or and then you got someone else saying pull the plug. So that became a big issue. So this document is basically a way for you guys to say, what do you truly want? Do you want your healthcare agent to make this decision, or do you want this document to supersede that decision at the end of the day? So again, very important.
One thing
Yes.
too, because we've had that discussion with our children.
Yes.
And you have to do it in advance.
That's correct.
Because when someone says, do you want to do this, I was a nurse and my father had a massive stroke, his mother had a massive heart attack. And they ask you, do you want us to put them on machines, and
Yes.
do you want a DNR? And
Yes.
you've gotta have thought that through, because you're always gonna say, yes, I want you to do everything.
That's right.
But that is, you've been designated to carry out their will.
Correct. That's exactly
And
right.
it's okay to talk to the doctors and everybody else about what are the chances, what's this, what's that, I mean, you can
Yeah.
do that.
Yeah, that's right.
What are the odds, you know?
That's right.
Or else just do it this way, but it's really important. I
It
think.
is. Very important. I'll give you one more example. My father-in-law fell, hit his head, rushed up to UNC, brain surgery. You know, they went to see if he had brain activity, and just unfortunately, just no brain activity, no brain activity, no brain activity. And in this particular situation, my wife has a stepmother, and then of course she has a brother as well. My wife has a brother, so you've got, you know, a blended family here.
Mhm.
So you've got stepmom, and you've got, my wife and her brother, and they're looking, you know, about making these decisions about whether or not to remove withdrawal care at the end of the day, you know? And think about that. I mean, it puts you in a really hard situation, because you're now here where the stepmom, you know, seemingly has the authority under the statutes to make the decision, but then you've got biological children, you know, and it just puts you in a real dicey situation. So, you know, that's why I say that having these documents, like you just said, is so important, because you end up in some situations sometimes that are not good at the end of the day if you fail to plan at the end of the day. So, yes.
Could you give guidance on how to choose an executor
Yeah.
of the will?
I would tell you that the way to choose your executor is you need to make sure that you can't, I don't know if you can trust anyone implicitly, but I mean, that is honestly what you have to be able to do. If you have any doubt in your mind whatsoever whether or not this person would ultimately uphold your wishes, then that is not a person for you at the end of the day. And you know, you can have co-executors. I do, you know, sometimes we have a lot of families with 2 kids, and they say, hey, I don't want to choose one kid over the other kid, so let's name them co's. And that's fine. No problem with that. Once you start getting more than that, kind of too many cooks in the kitchen, in my opinion. So, you know, try co-executors and all this. It just doesn't really work that well. But, you know, if you're concerned, blended family example, like we just talked about. Let's say you've got kids from a previous marriage on one side and kids from a previous marriage on the other. You know, sometimes you want to have a representative from each side, or you pick an independent executor to make these decisions in the middle, meaning they don't have a dog in the fight. So those are options that are on the table. But you know, fiduciary roles are so important because truly, they're standing in a role where they're managing assets for another. So you know, that is why it's so important. And yes, for wills, there's court oversight. You know, to basically say the clerk of court has to sign off on everything and make sure it's done properly and in accordance with North Carolina law. But hey, there's bad actors out there. There's people that are unscrupulous. There's people that will do things and try to get away with it at the end of the day. And you know, that's why it's so important to pick someone as an executor or power of attorney, or someone who you basically have the utmost faith in, that will do what you need. You're the principal. You're the guiding light. You're the polar star. You're the North Star. Make sure that your wishes are upheld and treat others fairly at the end of the day.
From your experience, would you choose someone from the family, or would you choose someone independent?
Good question. So I think it's different circumstances, different situations. The one that I just gave you about the blended family, I think, you know, if you have someone from a child at each that can maybe get along with each other, that's fine. But if you ultimately don't, then you got to go independent. I mean, you have to. It's just kind of no-brainer at the end of the day, in my opinion. You know, some people want their estate handled by an attorney, a professional. That's fine. We charge money for it. We're upfront with that. We'll tell you what the costs are, you know, but ultimately, you know, your affairs are going to be managed in accordance with the laws of North Carolina. You know why? I don't want to lose my law license. I want to make sure that I've got a duty to you as my client to make sure that I uphold those obligations. So that's an option. You know, we do serve as executor, not many, but you know, but certainly there's people there that don't have that individual, don't have that fiduciary they trust, or have some situations in their family that warrant needing an independent executor. But it's tough. You know, it's hard. I met with some people this week, and we were going through this very issue. You know, choosing these people of who's going to fill these roles, and they go, "This is hard decisions, Andrew." And I said, "It is. It's very difficult because you know we as lawyers have to plan for the worst and hope for the best." But I got to give you worst case scenarios when we talk about these things, about what can happen. And then ultimately, through our guidance and our advice, the decision ultimately will rest with our clients. And we will abide by your decisions at the end of the day, but it's our job to make sure you're fully informed of the ramifications of these decisions. Yes.
Talk a little bit about probate, and when
Yes.
did that happen, and what did you miss in all that planning that
Yep.
makes it go to probate?
Got it. Okay. So probate. All right. So probate means that unfortunately we've lost someone. All right. And probate means taking the will that hopefully you did and putting it on record with the Carteret County Clerk of Court or whatever county you live in at the end of the day. Okay. And basically what happens is the executor of the estate makes application for probate. One of the good perks of Harvell and Collins, we keep your original documents in our office, so there's no wild goose chase for the will. At the end of the day, it's kind of a tragic situation when someone comes in and goes, I got a copy of the will, but I can't find the original. Yes, we can probate a copy.
Yeah.
Much more complicated. So we've got your original will, we've got your application for probate. That goes over to the courthouse, and the will is admitted into probate by the clerk of court after reviewing all the documents. And then what that starts is a 90-day process in which you need to run an advertisement in the newspaper saying creditors come forward. And then after 90 days, we file an inventory for the estate, which is basically a snapshot of assets that were held individually or jointly by the decedent. And then ultimately, we pay those debts that come in. We pay expenses of the administration, final tax returns, all that kind of stuff through the administration process. And then ultimately what's left at the end of the day is distributed according to the will to the beneficiaries who are listed there under. Fortunately, probate in Carteret County right now, probate in Craven County, probate in Onslow County, all these surrounding counties to us is not that bad. It's a very straightforward process. It's not expensive. Wake County, Mecklenburg County, maybe Guilford County, Cumberland County, places like that with bigger cities is becoming much more difficult. So avoiding probate, which I'll talk to in just a second, could be advisable in those counties. But right now, fortunately for our clients who live in this area, I can tell you that probate is not the negative word, not negative connotation, because it can be accomplished fairly straightforward and fairly reasonable. Do a lot of estate administrations. We have very simple administrations. They're not that expensive. And ultimately, it's kind of a benefit for the client to be able to say, just keep your documents simple. Just keep with the simple documents. All right, now flip side, avoiding probate. And that's a good segue because that brings us into our trust talk. So in order to avoid probate, we have to create trust, okay? So what's a trust? A trust is a document that we have a legal holder and an equitable holder. And the legal holder is what's called a trustee. And that's very similar to an executor at the end of the day. And the trustee is responsible for administering the trust in accordance with its terms. And then we have an equitable owner of the property, and those are beneficiaries of the trust, okay? And in order to avoid probate, what you would need to do is we would create, and people have probably heard of this, especially out-of-state people, because there's many states like Florida and New York, kind of the bigger states, where probate is a negative word. And every estate attorney is going to tell you, create your revocable living trust, and you want all of your assets either titled into the name of that trust, or we need that trust to be the beneficiary of all of your assets. So when you end up passing away, you end up with nothing in your individual name. And everything you own goes into this revocable living trust. And the reason we call it a revocable living trust is because that way you can change it. You can make changes to it. You can ultimately revoke it and do away with it. If you want to change the beneficiaries, you change the beneficiaries. You want to change the trustees. Anything during your lifetime you can do with that trust document to make modifications and changes because it's revocable. At your death, it becomes irrevocable. And what that means is the terms are set. Okay? And the trustee must abide by those terms at the end of the day. And the beneficiaries must abide by those terms at the end of the day. So one trust planning tool is avoiding probate. It's a little cumbersome, meaning that you got to title all these assets. I mean, think about your cars, think about your bank accounts, think about things like that. There's a lot of front-end legwork to do to basically make sure that you end up avoiding probate by no assets in your individual names. It's why I'm happy right now that we don't have that situation in Carteret County, and Craven County, and Onslow County, that we can tell you, you don't need to take that step to go to the revocable living trust route. But look, there's a lot of clients out there that have been through a bad probate process who come to me and say, I want to avoid probate. And we set up a revocable living trust to them, and I give them specific instructions about what they need to do to avoid probate at the end of the day. And I'm happy to do that for you. But right now, we don't have to do that in Carteret County. It's not essential. Okay? Let's talk about some other purposes of trust. No, go ahead.
But, this is funny, and you'll laugh at me, but
Yes.
we did our will, and then we said, oh, we should probably go see somebody, and it had been 30 years since we had, and he said it's about time.
Yes.
But how often should you review your will and your beneficiaries and all that stuff
Good question.
at our age? Which is up there.
I think.
It's only 29.
So my cardinal rule is always any big life event,
Okay.
meaning if you have anyone, if you have a child, grandchild, if you lose someone who's involved in the plan, any major life event is obviously a time to dust off those documents. And then I'd also say any major transfer of assets. All right, what do I mean? I mean if you're buying a piece of property and selling a piece of property. I mean if you're taking accounts and you're taking money and investing it into like a large sum, not just your standard normal investments. Anytime you're doing something with assets or you have a life event, those are ding, ding, ding. I need to go dust off my will and make sure, because changing the nature of your assets can change the nature of the disposition. You can end up with I met with clients yesterday, and they go, properties 1, 2, and 3, sold, sold, sold. And then we've replaced them with properties 4, 5, 6, 7, 8, 9, and they're held in various different entities and different things. And we ultimately came to the conclusion after meeting that although they made all these swaps, nothing really changed at the end of the day. And that's what we came up with. It was like, oh, well, you did all this moving around to properties, but ultimately nothing changed. So you're okay. Your documents are all right, at the end of the day. But that's not always the case. And that's why they sat down and we had this conversation and we started building I love spreadsheets. I hate to say that. I guess that makes me a nerd. I don't know what to say. But we're, building a spreadsheet of assets and making sure that everything still is, the plan is still good at the end of the day. So it's, and then obviously, every, 3 to 5 years, I mean, if you haven't dusted it off, I think you should at least take a gander at it and make sure that nothing's changed. But really those life events and when assets change at the end of the day. Okay, trust planning real fast. Let me just get into a little bit. So I need to mention special needs trust because we have people out there who have special needs. What that means is if you're on government assistance in some way, shape, or form, meaning you have grandkids or kids or whatever who are receiving government benefits and we do not want those benefits to be interrupted, really the only solution is leave assets into what's called a third-party special needs trust, which is where someone will manage those assets for that individual and can dole those assets out pursuant to the terms of the trust, but their government benefits such as Medicaid, such as SSI, are not interrupted. So it's a very important tool if you have beneficiaries out there who have some type of special needs to make sure we don't, bump their benefits. It's kind of tragic when it happens. We've got some planning we can do on the backside to help fix it. But really the tool there is be proactive if you have someone with special needs in your life. Asset protection planning. So this is kind of the big boy. A lot of people want to know what happens if I end up needing nursing home care. Okay? Nursing home care. There's 3 ways to pay for it. And we're talking about, it used to be 7 to 8. It's getting to be 8 to 9, 10 to 9 to 10 at this point in time. And that's $9,000 or $10,000 a month. A month.
Yes.
Okay?
We're paying it now.
Extremely expensive. And there's only 3 ways to pay for it. Number 1 is called private pay. You can guess what that means. We're stroking checks. Number 2, long-term care insurance. A lot of people, a lot of our clients did end up with long-term care back in the day that was affordable, that you could actually get. It's just, the price of it's just gone through the roof. So if you don't have it, odds are you're not going to be able to get it at this point. And then Medicaid. Okay? So Medicaid means the state of North Carolina. It's a federal program implemented by the states. The state of North Carolina actually implements this. And that means the state actually is paying for your nursing home care. So what do? What we do is that we know the Medicaid manual. And we understand what are called countable and non-countable assets. Okay? So countable assets mean that these are assets that we take into account when we're determining whether you're eligible for Medicaid or not. All right? So easy ones, your cash money in the bank, any kind of investment accounts you have, business interests, various things like that. North Carolina says you can have a house. North Carolina says you can have a car, one car. So those could be non-countable at the end of the day. But countable assets are going to keep you ineligible for Medicaid unless they're below $2,000, and that's a very low sum of money at the end of the day. All right? Non-countable assets. One of the big tools in North Carolina is what we call tenants in common property. Okay? Tenants in common property means you have co-owners of property is basically the best way for me to describe that. And the policy behind it is that we don't want individuals to sell the family farm. Okay? And so what happens here is that we use that tool, which is that policy, which is tenants in common property, and we can take your countable assets over here. We can create two trusts, which is a 0.01% trust and a 99.99% trust. And we can ultimately have your real property held in that manner, and then we can use those countable assets and either go purchase property on the open market, and again, protect it in the 0.1%, 99.99% trust that we create, to take countable assets and make them non-countable assets and ultimately get you qualified for Medicaid at the end of the day. It also depends on the context here. So that's kind of the general rule, which is we can set up some trust for you, get you eligible, and then through the trust planning on the backside, the state of North Carolina files what's called a Medicaid lien and says, okay, we got a lien against your estate at the end of the day. And what we've done by doing the trust planning that we do is we make those assets non-recoverable, meaning they're not an asset of your estate at the end of the day, so that those assets ultimately go to your beneficiaries at the end of the day. So, hypothetically speaking, here you go. Let me give you a hypothetical and see if this helps clear things up. I got a client with $200,000 of countable assets. I've got a home place property that I put in the trust that I just mentioned here. Okay? That's what their assets are. They got to get below $2,000, right? So what we can do is we say, hey, do you happen to have any children that have property? And what the parent can do is buy a portion of the child's property at the end of the day, and we do a closing, and the parent buys, let's say the kid's property happens to be worth $200,000. Let's make it $210,000. so $210,000, and the parent actually takes their $200,000, and we'll say $198,000 of that goes and buys the kid's property, and that's almost 100%, but not quite. And we take that money, we put it into an account in the kid's name, and the parent now has a portion of the kid's property, and we put it in the two trusts. And guess what? That parent is now eligible for Medicaid because we have taken $200,000 of countable assets, we have bought real property, and we have made it tenants in common, which I told you is a non-countable asset. And that property, remember what's happened here, we saw a bank account over here with $198,000 in it, and we've got real property that's in the name of the trust at the end of the day. And now that person can receive Medicaid benefits, and we also have $198,000 that can help supplement their care at the end of the day that the child can help use to help mom and dad at the end of the day. So what I'm trying to tell you, and the reason I want to go through a couple of examples for you, and I'll answer your question, I just wanted you to understand that there are tools, and that's all you take home from this at the end of the day. We can build you a foundation for asset protection planning at Harvell and Collins, and ultimately you can live your life, okay? And then when something happens and we get a call and a tragedy's hit because mom or dad's gone into the nursing home, we're able to take a look at those assets and give you advice on how you can take those assets and get the person the care they need, which ultimately is unsustainable at $10,000 stroking checks at the end of the day. But also protect those assets either for the benefit of a spouse or for the benefit of the kids at the end of the day. What was your question?
My question is, how early does this need to be done?
Yeah, good questions.
Someone is already in the hospital.
Yes,
you know,
yes.
Or nursing home.
So what I would recommend to you guys out here is if you have a similar situation where you're concerned about this, we take your home place property and we put it into our asset protection trusts, and that builds a foundation for you to start with. And from those foundations, we now have your trusts that are in place. And you go live your life, like I said, with your IRAs and your investment accounts and your bank accounts and everything else. And then I get a call, and you call me and you say, hey, Andrew, my husband's in the hospital. Tell me what to do. Then I say, okay, let's set an appointment. You come on in here, and then let's talk about building the foundation of what we can do for Medicaid planning at the end of the day. Now, it could be, the way it works when you're in a hospital, by the way, just is if you go to rehab because your medical emergency, accident, whatever, you go to rehab in the nursing home, you have 90 days of Medicare benefits, okay? So Medicare will take care of you for 90 days. After 90 days, if you can't go home, we're back to the 3 ways to pay: private, long-term care, or Medicaid. So a lot of times we're getting calls just like you said, person's in the hospital, and maybe the advice is let's see how he does. Let's see, let's give it a chance and let's see. Could be we say, okay, we know that he suffered a bad illness, a bad medical emergency. We need to start this planning right away. And because we've built that foundation with your home place property or other properties that you may own at the end of the day, then we're able to take those assets and advise you on take this asset, do this with it. Take this asset, do that with it. Take this asset, do this with it. And at the end of the day, guess what we do? We hand DSS, who is who you apply with Medicaid for, we hand them a packet of everything we've done. And because we're playing by the rules. Remember, we're playing by the rules. This isn't hide the ball at the end of the day. And DSS looks through that and says, you're under $2,000, qualify for those benefits. So that's kind of the question, which is you're able to build a foundation, live your life, and then if you never need, I tell people it's insurance. It's the best way for me to look at it is insurance. You build a foundation with our Medicaid planning, our asset protection planning. I hope you never need it, because I hope you never go into a nursing home. And at the end of the day, what am I doing? I'm deeding property out of those trusts to whoever beneficiaries you've put in your trust document at the end of the day. But if you need it, I'm able to use those trust planning to make sure that you get the care you need and also protect those assets for your spouse or your next generation.
So when does the look back period?
Good question.
kick in?
Yeah, there we go. Look back period. Look back period. Look back period. 5 years. So 5-year look back period. So you're sitting there, Andrew, you've just told me I can be in the hospital and I can do this type of planning. Well, I can't. The reason I can tell you that is because what the planning that we're talking about right now avoids the 5-year look back period because I'm not making any gifts. Remember how I told you there was going to be a closing?
Yeah.
Remember how I told you assets were going to transfer? Remember how I told you I'm taking countable and making it non-countable at the end of the day? So I'm not breaching any rules. When you get in trouble is when there's gifts that are being made during that 5-year period. So a lot of people come to us and go, this is classic. Hey, Andrew, I want to deed my property to my kid. And I'm like, do you? Do you know what will happen if you deed the property to your kid? There's 2 bad ramifications of just deeding your property to your kid. Number one, you've now started the 5-year look back period. So if you need nursing home care within that 5-year period, there's a sanction that's going to be applied to that. And most likely you're going to have to undo that planning anyways. Your kid's going to have to give the property back to you, and maybe that property's going to have to be sold at the end of the day, which is not good. You know. Number 2, you've lost tax planning. Because what happens right now is that a state, you may hear of estate taxes. State taxes are very high right now. We're at $14 million exemption, more or less, indexed for inflation. Everything that you die with that's not a pre-tax asset, such as IRAs, 401ks, various things like that are pre-tax, get what's called a step up in tax basis, okay? So if you bought your property, you bought your house for $1, and it's worth $100 when you die, if that property's in your estate, it takes a fair market value of $100 at your death, and your kids go and sell that property for $100, they pay that. If I give my property away, so if I give my property to you before I die and I die the next day, you now inherited my $1, we call it carryover tax basis. So you now have $99 of built-in gain that you're ultimately going to pay a portion of that to the federal government. So giving your property to your kids is not the answer at the end of the day. What you want to do is use the tools, the trust planning that we have, where I can look you in the eye and say, you want to give your property to your kid. This document that I'm preparing for you is ultimately going to give that property to your kid, but it's going to give it to them in the best manner possible because it doesn't create a Medicaid sanction. And number 2, it's going to keep the tax benefits there where you don't lose that step up in tax basis, so your kids, when they get this property, they ultimately sell it, can, basically not have to pay the federal government any taxes on it. So that's the short answer to it. Yes.
It's my understanding that you have a certain period of time that Medicare covers you when you go there. Okay, that's 90 days.
90 days, yes, sir.
So, what I understand is that when that happens to me, Mary's to get on the phone and
Yeah.
call y'all.
Yeah.
Who has our paperwork.
Correct.
And you start this process.
That's right.
Okay, how long does this process take? If I die in 3 days.
Yes.
Are you out of luck?
So good question.
So,
I know.
so Mary's gotta come in there and say, George, you cannot die
Wait till
for
Monday.
30 more days. Yeah, wait till Monday.
Good question, good
And
question.
this is a personal application, but it's the theory that I'm not capable of following.
Yep. So kind of let me break it down like this, which is if you come in and do your documents with us today, all right, or tomorrow or next week or whenever it is, and we build this foundation for you that I'm talking about, you guys are good to go right now. Okay?
That's what you've told us.
Yes. You are good to go right now.
But she's to call you
Correct.
on the way that they're taking.
No. Look, here's the reality. I mean, we always tell all of our clients,
Yeah.
you're going to pay the first month of the nursing home bill while we're working on getting your planning in
Okay,
place.
Okay.
So, so I would just say that's kind of
A given.
a given. And why is that? Because I can't get you to go liquidate IRAs and 401ks and get investment accounts in the point we need to do immediately. It just doesn't happen that way.
But it's not important to understand why.
Yeah.
It's important that we understand what
to do.
Correct.
How to play the
Correct.
game.
And the reason I can't be more like specific about things, and here's why. Because the Medicaid rules say if you have a spouse, you're allowed to keep a certain amount of money. And it's based upon the amount of assets that you have. So what we would literally be doing at that point in time where she calls us and says, I'm so sorry, my husband is in the nursing home or he's in the hospital, he's gonna go to the nursing home under the Medicare, we need to know what to do next. Then it becomes, I hate to tell you this, it'd be like, okay, I need your bank statements, I need your investment account statements, I need all of this because we need to start building together because what Medicaid does is they take a snapshot of your assets and they say on such and such a day, this is what the assets were. And so we want to make sure that we have a clear picture about those assets. And Trish will tell you this, she helps us with we call it Medicaid spin downs because we want to spin down your money in allowable ways to get you qualified for Medicaid. We always say there's God and there's DSS. And they're almost on the same line when it comes to knowing about your assets at the end of the day. So you may think, hey, I gave some money to my kids, wink, wink, nod, nod. They'll never find that. It was, 4 years ago. And then guess what? They find it. They find it. And then we come to you and we're like, I'm sorry, now. And guess what? The good news is we can fix that. We can make sure, we can play that into the planning at the end of the day when we're spending down your assets in an allowable way to get you qualified for Medicaid. But I think the beauty of this, and I'm so glad you mentioned the 5-year look back period, I should have said something about it. The beauty of the planning that we put in place, Harvell and Collins, is flexibility. That's the key word. Because I can tell you that I can build you a foundation, and I can tell you to go live your life, okay? And as I said before, my happiest day is, unfortunately, when I can deed your property out to your kids, and I know you didn't need the nursing home care planning at the end of the day. It's great, because that means we did our job. We did our job, but and we're ready for you, but we didn't need to go that extra step because you didn't need that nursing home care. But in the event you do, it's worth its weight in gold because then all we do is take those assets and we start moving the pieces of the puzzle around to get you qualified, and we can avoid that 5-year look back period. Yes, there are other ways to do Medicaid planning. I'll freely admit that. There's irrevocable trust that we can set up, okay? Medicaid compliant irrevocable trusts. We take all your assets and we put them into this, it's a draconian document, for lack of a better word. The reason we choose not to do Medicaid planning like that is because it is a little bit, it puts you in a pretty tough box where your kids then, you're hey, can I get a cup of coffee, child, for the trust at the end of the day? Puts you in a really tough spot. So that's why we like to do this flexible planning with you guys where we know we built the foundation and we can take advantage of that in the event that you do need it.
And to add to Andrew on that also, when we do our planning, we can plan for the spouse that's going in the nursing home all day long, but we have found in history, we have to plan for the healthy spouse also.
That's right.
Because what happens if something happens to you first? You then don't want the unhealthy spouse to then inherit from you.
Exactly.
So
Exactly.
there's so we can't plan it all now. your little life is gonna dictate what we can do to help you.
Yeah.
And we try to cover all the what ifs. And that would be one of them, what if something happens to the healthy spouse?
And when talking with Andrew earlier, I gave him an example, my mom and dad, and again, this is that trust and respect of your loved ones. Dad always said, everything's in order. Don't have to worry about that, all taken care of. So dad dies first, and suddenly too, I mean, just, he's gone. So what does everything's in order look like? As I shared with them, took it to an estate planning, and nothing was in order.
Yeah.
So I think that conversation, if you're a parent and you have older children, you really got to start having a trust and respect conversation as well, that here are the documents, so you know what is going to be happening.
Yeah.
And make sure you trust your kids.
You know, and that's where I think Harvell and Collins does a really good job, because we encourage you, you know, please let your children or your family members, whoever may be named in these documents, know. You know, some people want to do that, some people don't. It's your decision to do that. But, you know, the good news is I can give you my card and I can say, if anything happens, please let whoever you named in your documents, your fiduciaries, know just to call us, and we'll be right up, Johnny on the spot, having your document, you know, ready for you. Oh, something's happened to Dad. Okay, let's get that power of attorney recorded. Let's you know, I'll tell you how to activate that. Here's what you need to do to go to the banks, all that kind of stuff. You know, oh, we've lost Dad now. Okay, let's set up an appointment. Let's go over the will, and let's go over what the steps of probate are and various things like that. And again, no wild goose chase for documents, because we've got them for you. I think it's a great service that we provide on that front. And you know, really there, because what happens in an estate planning context is we do your documents and then you go about your merry way. But just because you've done that doesn't mean you leave us, if that makes sense. You're able to then call, make changes. You know, it's just a really good thing. And I think getting a relationship with a lawyer to do your documents, a financial advisor if you've got, you know, that individual, your accountant, and having like a team approach at the end of the day where, you know, truly everything's in order, because all these professionals have you squared away at the end of the day. It's always really great, and it always makes things easy for your family at the end of the day.
And if the surviving spouse is not of sound mind, what plan goes into effect then?
Yeah, so
If there's no plan has been made, what plan goes into effect?
classic trust situation in that regard.
Okay.
You know, if you have a surviving spouse who's not in sound mind, and the question becomes, what kind of care does that person who's not in sound mind need? You know, there's different levels of care. There's assisted living, there's memory care, and there's skilled care, which is what we're talking about relative to Medicaid planning at the end of the day. Or is that person able to be on their own for periods of time, but just needs help? Classic example of getting money over to a trust for their benefit at the end of the day. So you make sure that your spouse is taken care of, but we understand they're not able to handle their own affairs themselves. So who could be that person to be able to do that for them? Could it be a child? Could it be a family member? Could it be a friend? Could it be a lawyer? And that's all options that are on the table. So, last thing is, anybody who has out-of-state property, so I know we got a lot of people who move here from out-of-state. If you do have out-of-state property, you do need a revocable trust. So let me just make that very clear, because I don't want you to own property in your individual name in Maryland or Florida or New York or wherever else. I'd like to avoid the ancillary probate. So we talk about probate in Carter County, very simple, very easy. But if you own property in another state, I've got to get documents filed in that other state in order to pass title to that property. So I do encourage you, if you own property out of state, that's another class example where I said trust would come into play and would make sure that we avoid that ancillary administration, meaning probate in multiple states at the end of the day. So yeah.
if our children all live out of state,
Yes.
so if I wanted to buy into any of their property
Yes.
to qualify,
Yes.
I would need an irrevocable trust at this point?
So you would need the revocable and irrevocable trust at the end of the day. And if you needed to buy into their property to qualify for Medicaid, we would hire an attorney in that particular state to handle the closing of the property.
Okay,
But ultimately, your North Carolina documents would be just fine to hold titles of that property at the end of the day. Same thing as if you own property in another state and you want to just title it in this Rev Trust, that would be perfectly fine at the end of the day. It's not in your name, it's held by these entities, no issues. It's just we're not licensed to practice law in those states, so we can't actually handle the closing. The out-of-state attorney would handle that for us, but your North Carolina documents would hold title to the property.
What if your child moves and they change that property, then you have to
Good
change it
question.
again?
Yeah, so we'd have to morph it over, you know?
Okay.
And, you know, that's the issue. So why do we like using kids' property? Because that enables you to have that sum of money set to the side to help supplement your care. Because let's be honest, Medicaid's not gonna take care of you entirely, that you're gonna need the extras, okay? If you go buy property in the open market, that's okay, the planning's fine. But remember, you're not gonna have that stockpile of money anymore to be able to help supplement your care. So unfortunately, we're looking to your children to step up for mom and dad and say, you know, look, we're protecting these assets for your benefit at the end of the day. So we want you to make sure you take care of mom and dad what I mean is you're going to end up with this stuff. So if you're going to end up with this stuff, then you come out of pocket to help pay for the extras that they need to take care of them, you know, is the right thing to do.
Okay.
So even if you have a will,
Yes.
you still have to go through probate.
If you have a will, you got to go through probate because you're going to end up with assets in your individual name. There's just almost every estate that I deal with, even people that have done a pretty good job of getting assets either transferred to their trust or trying to transfer assets away from someone if they're infirm in some way, shape, or form. They always forget about a car. They always forget about this. They always forget about that. So we end up going through probate, 9 times out of 10 with most people. Yeah.
So you also mentioned that the beneficiaries that you might
Yes.
list on your assets
Yes.
often are different than what you might list in your will.
Could be.
Does one trump the other?
Correct. Good question. So your account designation is going to trump whatever's in your will. So if I say I leave my life insurance policy to you at the end of the day, and then I go on my life insurance policy and I enter into a beneficiary designation and I designate Trish, my beneficiary designation to Trish is going to trump whatever's in my will at the end of the day. Okay? So if you do something different on your beneficiary designations that's not in accordance with your will, again, we want to make sure the plan's in place. So we want to make sure that if you did that you took that into consideration in your will. So we have certain times where people leave assets, IRAs, 401ks, various things by beneficiary designation, and then maybe the percentages in your will get tweaked because of that you've put there. So again, it's just very important to know that I want this asset here, and this asset here, and this asset to go here, and this asset to go here. And to your point, if we have that where beneficiary designations are different than what we have in our will, and we change the disposition of those assets, the nature of those assets, it becomes very important to dust your will back off because you could, again, create an inequitable situation because, hey, I've got all these assets going to these people, and now I've transferred those assets into another vehicle at the end of the day. Now it doesn't match up with what your will says, and the plan falls apart. So just be very cognizant that we honestly see more trouble with beneficiary designations and people adding joint owners of their accounts, then it's becoming a real problem. Because I think here's what happens. When you're in your lawyer's office and you're making these decisions, everything's like on your mind and you're in tune. And then you're just in a bank or you're just sitting with your financial advisor and it's just kind of more laissez-faire. And you're just easy just to go, well, yeah, let's just do that. And then you don't take into consideration the effect that you just did, which again, supersedes anything that's in your will.
Yeah. Also, there's the value, I think, of working early on with
Yeah.
someone like yourself is you're on top of all the legal changes that
Correct.
affect
Correct.
inheritance.
That's right.
If we made all of these plans that you're suggesting today, and something changed 5 years down the
Yes.
line and we were still alive,
Yes.
do you notify us
Yes.
of that change and
No
what
doubt.
impact it would have on what we've done?
Correct. That's exactly right. So we had a big change to the North Carolina Power of Attorney statute in 2018. So that was a big change. North Carolina completely rewrote the Power of Attorney statute. Now they grandfathered in all old powers of attorney, so they didn't go away. So, but the reality is that became a new document with new statutes, and that's an important change. And of course, we get that out, social media, newsletters, emails, discussions, letters, all kinds of things to be able to let clients know, this has been a change that's been made that you need to understand, and we would recommend updating your documents at that point in time. So.
I keep hearing you talk about Medicare, Medicaid.
Yes.
Is that Medicaid that
Yeah.
you're talking about?
So long-term care, yeah, when we talk about long-term care, it's under the Medicaid program. And again, the reason it's and what we talk about that is that's a means tested program. But because it's means tested, there are rules, as we talked about, where there are countable assets and non-countable assets. And so what we try to do through our planning is take countable assets and turn them into non-countable assets using the tools. And each state's different, so just bear that in mind. So what I'm telling you works in North Carolina, I had an attorney from Ohio come down here and tell me, that's crazy. I can't believe that works for you guys. And I said, that's what works for us. And he literally says, they've taken away everything in Ohio, basically, relative to Medicaid planning at the end of the day. He goes, we really just don't have many, I think they have Medicaid compliant annuities. It's about the only thing they've got. And that's a very limited option, let me tell you. So North Carolina, we're fortunate that we have more tools in the toolbox to help our clients.
Obviously, it's just a tremendous benefit.
Yes.
But, it's gotta be a huge drain on Medicaid, is it not? Potentially, people are really doing it?
Yeah. So, I mean, look, a lot of people, yeah.
Yeah.
And
I'm
look,
saying if everybody's out there doing it.
well, that's the thing. Everybody's not out there doing
Yeah,
it.
no, everybody's
Yeah.
not out there.
And I've got many files, guys, where two in particular that I can think of off the top of my head where, I told you can have a house, right?
Yes.
Told you.
Yep.
Okay? Well, these people have a house. The kid's living in it. Kid comes to me and says, Mom and Dad were on Medicaid. They qualify because, hey, they can have a house. And then I get their Medicaid lien, and it's $250,000. And the kid looks at me and says, what can I do about this, Andrew? And my response is, you can sell a house and pay the lien. Whereas if you'd taken the time and done the planning, I could have protected the house. So not everybody's doing it. And look, it's your decision about what you want to do. I mean, there's many times where Trish and I talk, and you mentioned about when do we call you. Well, you call us when you're in the hospital. You call us when you're in the nursing home, into the rehab phase. But just because you're in that situation doesn't mean that we automatically just jump right on it and go for it. We may say, let's take some time, pay the nursing home a few months. Let's see what happens. That could be an advice that that we give you at the end of the day. But the big thing for you all to hear, you're going to now be the educated ones. I hate to say that, because this planning that I'm mentioning to you, not everybody's doing it because people don't know about it at the end of the day. Now, we're fortunate enough because we have a pretty broad network of clients in Carter County who've gotten the word out. So when someone's in the hospital or has problems, hey, go see Harvell and Collins. They'll help you out with this. Because there's nothing more tragic, guys, than having spouses come to us and say, I've been writing $7,000 to $10,000 checks per month, and I'm just watching my account go. How am I going to take care of myself? And, we answer that question with saying, we can help you.
I have a very bright friend, and she's really into all of this stuff, and she's wonderful. Unfortunately, she wanted to come today, but she can't. But what she was saying, and I've had another friend who recently had a very young person die in the family, and they were just saying, and I don't think about this because I have a terrible time remembering my passwords, but they were saying that you better keep track of the passwords because this young girl had to take over her husband's business and didn't have any of the passwords. So you need to do it before, like have your password, and you can go on Amazon, she told me, and you can get a hard copy that you can have a book of as well as on your computer.
Yep.
But she said that it was really a nightmare, and it continues to be a nightmare.
It's becoming more and more prevalent.
Yeah, everybody's got 2,000 passwords.
That's right. And they did rewrite when they did the rewrite the power of attorney statute, and they've actually added to the fiduciary section, relative to digital assets. So there's powers that are in those documents to get, access to digital assets. But you are right. There's a lot of red tape with Apple. There's a lot of red tape with Amazon and other outlets trying to get access to these type of things. So, I 100% agree with you. And I think the more that we move on, and the more, I don't get any statements to my house. Not a single one. All of our bills, I don't get to see any bills. So this is going to become
paying your bills. I'm concerned.
Auto draft.
Auto draft. That's right. By the way, if I lost my wife, I'd be lost. I'll tell you all that. But at the end of the day,
You told her that, Lee?
we actually did. We had one of our friends. Tragically, she's 44 years old and died a couple weeks ago. and I'm helping, her husband with the estate right now. You know, and it's that same type of stuff, and I told my wife, I said, you know, I'd be lost if I lost you, and it really does make you think, because I think you bring up a good point about passwords, because I mean, I'd have to start figuring out, okay, who actually is our electric company and who is and start making these phone calls and doing these type of things. This really is a real issue.
Yeah,
So.
I mean, it's very time consuming,
Yeah,
and
it
it
is.
changes, but I mean, and this friend is so good, said, you know, she was thinking about something else, you know, with assets and all this stuff, and it's kind of frightening, because every time you turn around, you have to write down something, and then, I'm not good at Excel, I can't
Yeah.
even do Excel, so it'd be much easier if I could do Excel, mine are all on Word or whatever, and poorly, you know. But anyway, it really is daunting, it was much easier to die and just get put in a brown box and buried in the backyard, honestly.
Has anybody been to our backyard?
Oh, goodness.
But
Got all
thank
these
you.
plots.
Yeah, thank you, but you do cover digital if we go, because we didn't really cover digital assets, I don't think, when we had our will done.
Yep.
I think it was 2017.
Probably not. These are kind of newer things that have been added to the statutes.
Okay.
So, yeah.
Oh, yeah, okay.
So
Thank
anyways, no problem. Anything else?
So,
I do
and
wanna
one
just-
last question, I don't wanna, hopefully don't make it too specific, but
Yep.
if you, in the case you just described of the 44-year-old.
Yes.
Leave behind, if the spouse that died had no income, not working, no retirement account, what sort of financial obligation then does that leave for the surviving spouse, for their quote, if you will, the estate?
Yeah. So the kind of long and short of it is that whatever obligations are there, I mean, in this particular case, you know, you've got a mortgage.
Yeah.
Surviving spouse has to pick that up. You know, but as long as those debts are just in the spouse that dies name, then there's a way to try to manage some of those debts potentially, meaning like a credit card, for example, medical bills, various things like that. There's a year's allowance in North Carolina that allows a spouse to take the first $60,000 of probate assets to the before any creditors get any bite of the apple.
Okay.
So, you know, there's a way to help manage that, but most of the time, you know, we see spouse debts are pretty joint. So, you know, in that regard, it is a financial burden on the surviving spouse, because now there's not two incomes. Now there's not, you know, these things. So I tell all my friends that are my age, term life insurance, just go for it, please. You know, it's not that expensive. And, you know, I mean, I've got 2 kids. Most of my friends have children. I mean, people that are our age need to take advantage of that, because it is a tragic situation. And in this particular case that I'm mentioning, there's not much life insurance. There's a little bit, but there's not much there. And, you know, it's important. People that are my age, I mean, guardians in their will are extremely important. I mean, what happens if that plane goes down? What happens if that car accident happens? I mean, heaven forbid we had the first Baptist preacher, I mean, lost his wife. I mean, just things like that you just think are unbelievable happening, and they happen. And then, you know, you're left with a very difficult situation. And we're handling an estate right now where we lost both parents, and we've got a 9-year-old child. You know, no wills.
In my own personal life, I became a widow at 38 years old, and my husband left me with $1.4 million in medical bills. And a 13-year-old son, and I thought I was gonna lose everything, but because of good planning,
Right, good.
you know.
So yeah,
I
those
didn't
are
lose it all.
yeah, they're just tough circumstances, tough situations. But again, I think Trisha's right. Planning. I mean, planning is just the key to all this. I tell all my clients, I say, look, you're gonna pay a little bit of money for your estate planning documents, for your asset protection documents. It's nowhere near what you pay if you don't plan.
Right.
Because if I'm having to take care of things on the backside, you better believe it's expensive, because the court's going to be involved, and you know, in other things like that, we have to post bonds. I mean, there's just tons of things that come into play where it becomes much more time consuming, and again, time is money when it comes to attorneys. I mean, that's just the nature of our business at the end of the day. So.
I've mentioned this to some, it's you're probably familiar with it as well, it's a book, I'm dead, now what?
Yeah.
You know, but what's good about it is it gives you prompts sure you cover, you know, accounts, credit card numbers, you know, savings
Everything.
account numbers,
Yeah.
passwords, but a wide variety of living things that you should pass along to people in some manner before you die.
Yep.
So it's on Amazon, you can get it, it's really a good product.
And the surviving children, if
Yes.
they're under age of majority,
Yes.
those do receive some sort of social security benefit?
Correct.
Okay, all right.
Yeah, they
So
will.
in that case you're describing, they would get something.
They will get something, that's
Okay.
right, so you'll have a situation there, and then bear in mind, if you have a will, and you have a trust that's built in there, then you don't have to worry about a guardianship
Okay.
for the minor child, but if you do not have a will, and, you know, you have a grandchild or a child that inherits, through intestacy, then you're looking at a guardianship. So for the example that I gave you with the 9-year-old, that 9-year-old and her grandfather are in our lives for the next 9 years.
Right.
Because I'll have to be doing guardianship accountings for them for the next 9 years. And fortunately, the family, the parents were very successful and did leave a lot of assets. But then bear in mind, that's a lot of assets I gotta account for
Right.
through the guardianship at the end of the day, which if that just would have done a will, it would be in a trust, and that would avoid those costs and expenses at the end of the day. Which again, clean it up on the backside versus planning on the front side. And again, if you take anything I've said, planning is the way to go. It really, truly is. And I hope that each one of you sitting out there, whether you hire Harvell and Collins or not, you know, goes and sees an attorney and gets your basic documents taken care of. And then if you need that advanced planning, you know, build that foundation and get things started. But I really appreciate you guys letting me be here.
Thank you so
Sorry if I went on a little long. Thank you.
Andrew, thank you very much for being here, and I think everyone here probably has another question they want to ask. So I just want to encourage you to sit down and do your individual discussions with an attorney, whether it's Harvell and Collins, which we use. I think it's important to know that there are other things you can do to take care of yourself. So thank you again, Andrew.
Thank you.
And Tricia as
Thank
well
you,
for
sir.
helping set things up. Appreciate it. And we'll, I'm gonna stop